So let's take these up one at a time. First, the jury learns the law after the fact. So what I want you to think about, and we talk about it in other lectures and other videos, but we always start, and I always start the first lecture of the year, talking something about closing. Because if you want to understand trial and you want to understand what's going on at trial, you must start with closing. You must figure out where you want to end up at the end of the day, what you want to be saying to your jurors, what you're going to ask them to do. You have to figure that out first. And I'm talking about figure it out first before you even approach the case, open the case file. To know how to put together a case, now I was a prosecutor too, like Professor Cambray, to put together a case, to put together who are going to be your witnesses, what are going to be your exhibit, what batting order is that going to go in, how are you going to tell this story and in what way, right? You have to know where you're going at the end of the day. You have to know, ideally, at the end of the day, when I stand up before my jury, what do I want to be saying? How do I want to be arguing this? How am I going to urge them to go back into that deliberation room and carry out exactly what I'm asking them to do? I start with my jury instructions, and I start with closing and where I want to end up at trial. So that's for a different lecture. I have a video on that already about starting with jury instructions and going backwards. You also know that you build your case in that way. You build it to meet those elements, right? You're going to learn about elements. You're going to learn to love elements, whether the elements of negligence and torts, or the elements of a robbery in criminal law, or the elements in advanced courses of what is the cause of action. And if I'm the party with the burden, if I am the proponent, if I'm the one putting on witnesses and putting on exhibits and putting on evidence to meet the elements, right? I have to organize my case that way. I have to think about it with that in mind. Now, Professor Leff and other defense counsel think about it from an opposite perspective. They're not the party with the burden as the criminal defendant in a criminal case, or maybe a defendant in a civil case. Instead, they're looking at those very same elements and that very same legal backdrop as how they're going to defeat it. What holes are they going to punch? What element are they going to focus on to illustrate that the proponent did not meet its burden, did not carry the day, can't urge you to do what they're asking you to do? Well, with those two things, understanding that we start there and understanding that we assemble our case with that in mind, we have to think about when does the jury in fact learn about this? Now there's something that's called the jury instruction conference. It's a time when we sit around as lawyers with the court, sometimes it's in chambers, sometimes it's in open court, where we sort of resolve the law. The way you need to think about it, while that does happen either during trial or immediately before trial, from your perspective, the law is essentially 90% resolved by the time you make it to trial. You know the cause of action, you know the key definitions, and you know the key instructions that are going to be part of that trial. As a matter of fact, I did federal work, and most of it's on a publicly accessible webpage. The Ninth Circuit jury instructions in criminal law are something that you can find. If you want to hear that it's this type of case, we're going to talk about a robbery case today. If you want to focus on robbery in a federal criminal trial, then you go to those jury instructions and you click off the ones that are applicable and the ones that you're going to be arguing off of when you in fact get to trial and when you're arguing in your closing argument. So, although it happens during trial, and although it could be, at night after you've put on witnesses, and it could be during, you're really fine-tuning the ultimate words that are going to be read to the jury. The law is set out beforehand. Now, the last thing that I want you to think about is when the jury learns. For those of you who are upperclassmen that have been through those exams in your first years, who are looking forward to your first set of exams, right? You often are armed with the law. You know the law. You know what the cause of action is before it. And then, as evil law professors do, we give you a complete array of facts that you have to then analyze against it. We don't afford that luxury for our jurors. Think about it. We put on a whole trial, and it's not as organized as just a factual scenario, as just an essay question, right? Trial is the most disorganized presentation of the facts you could possibly imagine. Why? I put on witness one, and I ask my questions on direct examination of the things that are helpful to me. And then guess what? My opponent gets up right after that and goes on cross-examination and asks their questions and her questions that are favorable to their side. And so goes with witness 2 and 3, so goes with every exhibit that I introduce. My perspective on that exhibit is put before the jury, and then immediately thereafter, questions on cross as it relates to that exhibit. It is a disorganized, crazy presentation of a factual scenario. And that's the one that we save for our members of the community. When I say members of the community, go down to a BART station. Round up 12. That's your community, right? Have you been to the DMV, right? We're talking about people from the community, not the smarter sector of our community, not those interested in the law, not people studying the law. And we give them this disordered array of facts in this way first. Then at the end of trial, we present those facts to them. Let me talk about that. So this robbery, here's a 9th Circuit model instruction, has a bunch of preamble language, and eventually, it gets to the elements. Here's the elements of a Hobbs Act robbery. In federal court, when you jack someone of their stuff, and that stuff traveled in interstate commerce, you too can be the proud owner of a Hobbs Act violation. You too could be a Hobbs Act defendant. Here are the elements. I should have looked at this a long time ago. I should have planned my case to meet these elements. I should have thought of which witnesses and which exhibits with the idea that this screen, at some point in closing argument, was going to be behind me, and I was going to be able to walk you through it and show you why I met element 1, show you why I met element 2, show you why element 3 isn't even going to be at issue because we stipulated to it. Everyone see it? I got to think about this ahead of time, and I present it ahead of time. But think about what I just told you with when the jury meets the law. They literally see this for the first time at the end of trial, when I put on all my witnesses, when it's had that convoluted display of cross-examination and then redirect and then my version and her version and their version, right? It comes out in this disordered way, and it's for me, in closing, to stay on the path, stay within the framework, and organize it for my jury. It's my job as the attorney to organize it.